Welcome back to Checkpoint, this very first episode for the year 2017. And tonight, my guest is somebody I spoke to a little earlier, Professor Githu Muigai, who's Kenya's Attorney General. We spoke about a wide range of issues. That motion to be tabled by Majority Leader Aden Duale on the conduct of Justice Odunga, the amendments to the Electoral Law, and whether 2017 will be the year we finally see the implementation of the two-thirds gender rule. Also, remember that sticky matter of PS Karanja Kibicho and that sentence, jailing him for contempt of court? How about Cabinet Secretary Nkaiseri? There's a warrant of arrest out for him. Is there selective application of justice? My conversation now with Attorney General Professor Githu Muigai. All right, thank you very much, Professor Muigai, for speaking with us on KTN. I think we want to start off by taking a look at some of the big things that have happened in the legal fraternity. And I think the one that people will remember at this point is what happened in the National Assembly with the passing of the amendments to the Electoral Law. A lot of people decried that atmosphere in which that was done, the way it was done. What are your thoughts on what took place in the National Assembly?
Well, I think that we are having some teething problems as our democracy settles down. In an ideal situation, the House should conduct itself with greater decorum, obviously, with greater order. The Speaker should have greater control of the procedure. So one cannot say that that is the ideal way that the House should operate. Having said that, however, I assume it is possible to say that the will of the majority was recorded in the manner that the standing orders provide. And that those questions are now before other forums for resolution.
But then they talked about the way in which the amendments were passed, that the amendment to the initial law itself came from a bipartisan approach with a joint parliamentary select committee, and that if any changes were to be made to that specific law, that it should have been subject to more consultation. Some saying the majority side was sort of bullying its way with passing that law. Do you agree? Because there was also the question about extending the term of the Joint Parliamentary Select Committee or finding a different sort of body to midwife that process.
Well, as you will recall, when that process commenced a couple of months ago, I was invited by Parliament to talk to them about my own thinking of where we were in terms of the impasse around IEBC. And I advised in broad terms that if the worst came to the worst, we would have to let the commissioners go, and we would have to rethink questions about timelines and so on and so forth. And much of what I told the committee was taken on board. But when they went to the drafting part, they did not call on my expertise, or rather the expertise of my officers. They did it on their own. So essentially, it was a parliamentary initiative. In fact, I was shocked to read in the paper some politicians attacking me for failure to advise that the law should have been in one way as opposed to the other, when everybody who cared to follow the process remembers that it was wholly and exclusively a political process centered in Parliament. Indeed, the politicians themselves agreed not to make any alterations whatsoever. To the extent that now, on second thoughts, they seem to think that they didn't quite capture the essence of what they wanted. I think it is legitimate to reopen the question. Now, the direction that will go, I do not know. I have been summoned by the Senate on the Tuesday, and I intend to go and give them the benefit of my experience.
All right. Do you think, in hindsight, it should have been subjected to debate? I know both principals from Jubilee and CORD urged their members in the National Assembly to pass the amendments with changing not so much as a comma or a full stop. And we know and understand the process of lawmaking. In hindsight, Should
To the extent, the reason we first went to Parliament to look into this question was because we wanted to prepare ourselves for free, fair, peaceful elections. To that extent, that spirit must be retained, because we do not want anything that can poison the electoral process. To my mind, the direction Senate is going is a good direction, because it's a direction that says, let us reason together, all of us, and see where we can give and take, so that this ceases to be the issue, and the issue becomes building IEBC, capacitating it, getting it to procure what it needs, and revisiting the voter register and making sure we are ready.
Professor, there have been some people that have said we cannot possibly be ready in time. My question to you is there any window in the law that would allow the election to be postponed? Or do we just say, you know, do or die, it's August, whether we can get this ready or not?
We must do everything humanly possible to do the election within the constitutionally mandated time. However, should a big if for some reason we are not ready, then it is better, in my judgment, to postpone the election within the limits of the law, other than have a deeply flawed election that can lead to instability of a nature that none of us want to see.
What would that provision in law be as you advise the country right now? And like we said, it's a big if, and we're seeing efforts being made to make sure that we are ready in time. But should we get to a decision like that, what would that window in law be to allow the election to be postponed from August?
There have been initiatives in the past that I'm aware of in Parliament. There have been bills that have sought to change the voting date from August to December. I believe that bill was defeated once. I don't know whether it was shelved or that is one way of going about it. That is to change the election date itself for all time.
That would require a referendum, though.
It would require some initiatives, but I'm not sure that at the moment anybody is willing to open that window. And then, of course, there is another simpler route, which says that Parliament by resolution can extend its own life if Kenya is at war, etc., etc. Now, we would have to rethink very seriously around all these issues. For now, I don't want to be the one to suggest that we should open the book on those at the moment. I want to remain with the theme, the message that let's capacitate our IEBC, let's work day and night, let's procure, let's audit the register, let's register new voters for the last time, let's print ballots and get ready.
Okay. Let's talk about the IEBC now for a moment, because we know the president has picked Wafula Chebukati for this. And now the question of regional balance, which is enshrined in our constitution, comes up saying, should Parliament vet him and he gets the final appointment, then both he, head of the commission, and the head of the secretariat would come from one region. And we've spoken to a number of actors in civil society who think that perhaps we take this question of regional balance a bit too far.
I agree entirely. I think we overdo it. The spirit of the Constitution is that we shouldn't have an over-concentration of individuals from the same religion, the same ethnicity, the same geography, etc., etc. But the idea is not that you get two good people who can do a good job, and then you have to you have to go and look for some other less qualified person to achieve an ethnic balance. So I wouldn't spend a sleepless night on this myself.
Okay, so
and I agree with civil society if that is their position.
All right, okay. They will be happy to hear that. Let's talk about what happened outside the National Assembly after the amendments were passed, and the statement from the Majority Leader Aden Duale, worried a lot of Kenyans, and it was a very direct attack against a member of the judiciary, claiming bias on the basis of tribe with some of his rulings, and in respect to that ruling regarding that special sitting that was there. And some saying, including the LSK and the Chief Justice himself, saying this was uncalled for, this was intimidation. What's your reaction to that statement by the Majority Leader?
I think that first and foremost, we must recognize that free speech is an important part of our democracy. And in recent years, we've seen a lot of free speech that is also extremely robust. Having said that, I must say that the integrity of the judiciary is absolutely critical to the well-being of a democracy. The judges are not elected. They have no forum to answer back. Obviously, the judges are professionals. They are human beings. They are subject to error. But the manner in which a judge can be criticized for his work is very well laid out. And it is inappropriate that a judge should be the subject of political commentary in forums that he cannot. And that is not to say that judges are immune from criticism. In fact, we lawyers spend all our lives trying to explain to a higher court why the other judge was wrong.
Right. So there's an appellate process.
Yes. Why he didn't understand the law, or why he was biased or something. Yeah. So we attack judges every day. But the decorum and the dignity and the process for doing that must be retained. Because if we begin to attack judges in a very violently political fashion, we will not be able to respect the outcome of that. So if we hold an election, if the Supreme Court says X has been elected and not Y, it means then that we can disregard the judgment because we can attack the judgment politically. So my own caution to all politicians, and there are many, is that we have to allow the judicial process a dignified existence. And even where we disagree, and we are entitled to disagree, we must moderate the language we use to address judges.
Because you mentioned an appellate process, but there's also the JSC to which any individual can go to if they're unhappy with the conduct of a judge. But then we hear that there's a motion that's going to be tabled in Parliament to discuss Justice Odunga, and it's going to be moved by Majority Leader Aden Duale, and he's proud to say that he will be the first to have done this. Talk to us about the legality of having a motion in Parliament to discuss a member of another independent arm of the state.
Well, that Parliament has oversight. It has oversight over all of us. Because in principle, Parliament is the ultimate embodiment of the people of Kenya. They can have a motion to discuss any person serving in the public, including a judge. It is very, very, very rare in a democracy that is invoked. I therefore feel that it cannot be said that Honorable Duale has no right to do that. Maybe one can ask whether there are other ways of expressing this discontent in a manner that continues to protect Parliament and continues to protect the dignity of the judges and of the court. And
what would a motion in Parliament, though, achieve?
Well, it would be a form of censure, I assume.
Yeah. And what would that lead to?
In fact, legally speaking, it not much, because you cannot remove a judge because you have a parliamentary motion. You can remove a judge if you have a process through the JSC and then to the tribunal, to the president. So other than probably making the political point that there are people who are dissatisfied with the work of a particular judge, it doesn't achieve much, and may set a very, very I'm looking for the right word, may set a precedent that may be inappropriate.
Okay. I'd like us to talk about something else that has plagued the country the entire year, because we're at the end of 2016, and yet again, the two-thirds gender principle remains unimplemented, unresolved, and some say this falls directly at your doorstep.
Well, I can tell you, nobody, and I mean nobody, has done more for this process. You recall towards 2012, when we were going into the last election, I personally got very worried that we could end up with a parliament that could be declared by the court to be illegitimate.
Right.
And I went to the Supreme Court and I said, please guide us on this law. And the Supreme Court, with a majority, the Willie Mutunga Chief Justice dissenting, said you can implement this slowly and we give you up to 2015 to do it. I set up a task force and they went around halfway around the world. They came back with all manner of proposals. We drafted a bill. President approved that bill. We negotiated it with the Women Caucus in Parliament. They approved it. We went to Parliament. It was defeated. It was defeated. I didn't give up. We started another round of negotiations. We tinkered a little bit with that bill that became the Duale bill. Again, we went with it to the House. It was defeated. Senator Sijeni got her own bill. We got behind her. We supported it. It went to the Senate. Just this week, Christmas week, it was defeated. Now, I have myself written to both speakers very, very strongly worded opinions saying I entertain the gravest possible doubt that we would withstand a constitutional challenge in 2018. Just when I had dispatched the letters to the speakers, we got this judgment from the High Court saying that even cabinet itself has to be re-examined.
Right.
So I come from the school of thought that believes we need to do something about the two-thirds gender rule.
And what is that? Because you've talked about all of these efforts that have been put in place. What is the challenge with implementing this?
The challenge is getting the numbers. There aren't enough people in the House who are convinced that this is a problem. In fact, I have met many people who've told me...
Even though it's in our constitution?
Yeah, I've met many people who keep telling me, you are the one who is creating a problem where none exists. We are all happy. There's no problem. Parliament will exist with or without two-thirds.
How about putting in place a regulatory framework to bind all political parties towards this issue?
We've tried that. I can tell you we've tried everything. Now, political parties don't want to be thrown this problem because then they would have themselves to pick the women in their constituencies. Now, they want to pick the candidate who is most popular so that they can win. They want numbers. So they don't want the process of implementation of the two-thirds to be their problem.
Some say in an area where you've got a sphere of influences and the advice that you give to the president in how he constituted his cabinet and that to be in line with the two-thirds gender rule, there had been complaints about it after the reshuffle. Persons went to court. We've now seen what happened in the court, and even that judgment suspending it for 8 months, which then sort of says it allows this illegality to prevail. But what advice did you give the president with respect to...
It's very sensible when a court warns itself of the danger of creating a constitutional crisis in the middle of other problems. So to the extent that the judge says we suspend this for whatever, I agree with that entirely.
So do we remain with an illegality, Professor?
Well, you see, there are... This whole question, by the way, is an old question. We litigated whether the Supreme Court itself is properly constituted.
That's another
You recall,
yes.
and then we were advised that since we can't have half a woman, half a man, it was okay. The reason the government, the reason the president makes decisions, his deputy makes decisions, cabinet makes decisions, there are numerous reasons. And on the whole, all we have to keep advising is whether this is consistent with the law. Now, we ourselves have a certain view of the law, and the court, on a number of occasions, says, no, the government's view of the law.
And what is your view of the law with respect to the constitution of the cabinet?
I took the view myself up to this point in time that that the judge has made a different interpretation that cabinet was safe. Now we are studying the judgment. We will, when cabinet resumes, we will discuss it, debate it, and then it will become part of the bigger discussion about 2/3.
All right. So, just to understand, the cabinet is not constituted based on the 2/3 gender principle.
Right now.
Is it?
As far as we're concerned,
Yeah.
it is. As far as the court is concerned, we are not.
Okay.
So we have to
All
now, at an appropriate forum, debate what the court has said. And in any event, since it is applicable in the next cabinet, we put in place, if we agree with the court, we put in place the necessary instrument. If we do not, we go to a higher court and say there is a misapprehension as to what this means.
All right. So there's a possibility of it.
That's a possibility.
Okay. Let's also talk about then a number of incidents with respect to respect for the law that we have seen this year. Arrest warrants out for Cabinet Secretary Joseph Kaiseri, Monica Juma, when she was at the Ministry of Interior regarding, that ship that was blown up in the high seas. There is that, and there's also the PS, Karanja Kibicho, who is to be jailed for contempt of court. This has not happened. They are still walking free. And some say that the government itself is unable to respect the rule of law and to carry this process out. Do you think this sets a bad precedent? Why should anybody else obey the law when the government does not do so?
Clear. I want to make this absolutely clear. A court of law that purports to issue an arrest warrant in order to enforce a debt is acting contrary to law. There is binding precedent from the Court of Appeal where the Court of Appeal has said you cannot do that. That is illegal. Now, when you say to a permanent secretary, we want you to pay Mr. X 1 billion shillings because a judgment was rendered in his favor 5 years ago, and where the response is, we need budget. And then the response becomes, that is a way of hiding from your obligation. The courts that have done that contrary to law. I have spoken at Judges and Magistrates Forum on this point many times, and I have spoken to the Chief Justice in the Judicial Service Commission, and I have said we are seeing a harassment of public officials contrary to law. But now we've gone further. I took to Parliament the Contempt of Court Bill. It has now become law. It is the Contempt of Court Act 2016. And there we specifically provide, and I drafted the provision myself, that no court of law shall issue a contempt order in respect of a payment of a debt owed by government directed against an accounting officer.
So what happens to those who are seeking justice? In this case, in this particular case, this individual who has been seeking justice in the courts for 5 years or more, what happens to him? Because you're talking about the Contempt of Court Act, but what about those people who get into a situation where they're wronged by government and it's one individual going up against, to be very fair, Professor Githu Muigai and a host of other government officials?
Okay. What is to happen if we were to arrest Dr. Kibicho because he owes Mr. Hussein, or rather the ministry owes Mr. Hussein 1 million? So we send him to industrial area prison. But then what do we do with the money he owes Mr. Ali? He comes out, we put him back. So
Wouldn't that compel the government to make its payment as per the law, as per the ruling?
The reason government is working on a process of processing debt owed to the public is precisely this. We want to have a payment system that is professionally managed, okay? And we pay claims in accordance with their age and so on. And part of it is to beat corruption, because there are cartels, I'll be the first to admit, specializing in collecting checks from ministries, if you are owed money by ministries. They have.
But wouldn't you want to deal with that on a case-by-case basis, Professor? If one individual has to wait 5 years for a judgment like this to be enforced, where's the justice for those individuals who are going up against government? Fair enough, there could be cartels, but not everyone seeking justice from government agencies, is out to get you.
I grant that. Well, I think that the legitimate question that you raise is that government ought to be setting up a process of paying its debts that is open, that is transparent, that is well funded annually, so that the Minister of the Treasury is able to say in his budget, this year we have put aside 50 billion to deal with historical claims pending against the government. I have been in favor of that. We have had very good discussions at cabinet level about that, and I think it's something that would definitely happen in 2017.
All right, that's in respect to a debt. But for the Cabinet Secretary in Kayseri, it's about another matter altogether, about going against a court injunction, blowing up a ship that would, some say was part of evidence in a court proceeding. That is a different matter altogether. And then you have the members of the Doctors' Union who are up for a contempt of case court. Correct me if I'm wrong, fairly similar, going against a court ruling. Then some say if that arrest warrant cannot be effected against a cabinet secretary, surely it shouldn't be effected against anybody else in a similar circumstance.
Ideally, we should have all court orders having the same force of law. And we should have all court orders enforced in the procedures set out in the law. Unfortunately, the court orders emanate from different types of proceedings. There are court orders in divorce matters, there are court orders in civil matters, there are court orders in the criminal process, and so on. And I must be one who would accept that we ought to do more to ensure. And one of the discussions I've had with the Chief Justice is for us to bring back the bailiff system. And the bailiff system was a system where the court had its own enforcement officers. So if you have a court order, you don't have to go and look for the local police station. You have the bailiffs who are able to enforce the order.
But with respect to this one, though, you're talking about a bailiff. This is a cabinet secretary who's in charge of interior. We see him at various press conferences and at various events with the person who is in charge, ideally, of enforcing that. He and the Inspector General of Police.
That's where the arrest should take place.
Well, no, I'm just asking because in terms of optics for the nation, they're saying, but we see these two together. What would be so difficult in enforcing that specific arrest warrant?
In most of these cases, by the way, we normally intervene with the court as soon as such an order is made by way of a follow-up application. Seeking to give an explanation. And 9 out of 10, actually, courts listen to this and they vary the orders or set them aside. However, I want to concede this. We do justice to the rule of law if we enforce court orders expeditiously and in respect of all persons. And that's an ideal that we must continue working.
So will we see the cabinet secretary get arrested anytime soon?
I would hope that we will not need to arrest any cabinet secretary, because they will be obeying the law and doing what the law says.
Because it does. Don't you think that certain senior people are untouchable because they're
That's not the message,
a cabinet secretary?
That's not the message.
What do you think?
That's not intended to be the message.
However, don't you think?
I'm sorry you feel that way.
Speaking on behalf of Kenyans.
I can tell you that's not government policy.
Okay.
Government policy is that we must enforce court orders.
All right.
And we must enforce them across
All right. Against all persons, big or small, everyone in between.
Subject to the law.
Subject to the law.
There are many persons with immunities but that's not what we want to discuss now.
Yeah, that's a conversation for another day. Yeah. It is indeed. As we close, Professor, where do you see us going with, in 2017, there's an election coming up. There's so many laws that are in the air. And there seems to be a lot of disquiet in the country. With respect to the laws that we have, the ones we're trying to change, the ways in which we're trying to change them, and with all that we have discussed, what assurances are there that, one, the law shall prevail, that the advice that your office will give to the head of state will be sound to guide us through what is a politically polarized environment over the next few months?
This is a very vibrant democracy. Even you would be the first to admit that. It's an extremely vibrant democracy. I think our people are probably the most articulate on this continent about politics. They know what they want. They say it loudly. They say it on social media. They say it in public meetings. I never fear for this country on the basis that that the gains we have made can be reversed. They are irreversible. All around us, countries are talking about extending presidential terms. Have you ever heard any Kenyan raising that issue? It is completely behind us, and it will never come back again. Now, 2/3. Everybody is in agreement. It's about implementation. Nobody in Kenya can say, this body constituted wholly of men is okay, let it continue its business. No. We have made such gains that are irreversible. This doesn't suggest that we don't have problems. Of course we have several problems. Immediate problem is to stabilize politics, so that politics does not affect the major transformations we are making in the economy, in education. I think in education we are doing very well. In agriculture.
From a legal standpoint, how would we stabilize our politics? What are some of the laws that we can have in place to make sure that we are where we are? And maybe you can just speak about that.
Politics can only be stabilized by politics. Law guides. Yeah. I am in favor of, and like now we've just brought in a whole new corpus of laws around corruption. Mm-hmm. We even have a new bribery act. We have a whistleblower protection act, and so on and so forth. These are good things. They are good initiatives. But ultimately, it is the politics that makes it possible for these laws to be applied firmly, decisively, expeditiously. The minute you arrest a governor or some politician, and there is a whole demonstration by villagers and others coming to say, why have you touched our man? This is the politicization of corruption is probably the worst impediment we have in the fight against corruption.
Wouldn't it be stopped by the law being seen to be done, going beyond arrests and actually having convictions, these so-called big fish, and frying them?
And that's exactly what we're doing. I'm the chairman of the MAT, the Multi-Agency Task Force, and we meet every 2 weeks, precisely to do this. Mr. Investigator, how far have you gone? How much more time do you need? Mr. Prosecutor, why have you kept the file since you got it? And so on and so forth. We ask ourselves questions about this, and it's working. The machine is beginning to move. And you can see, just this Christmas, people are still being charged. We went and opened the anti-corruption court the other day with the Chief Justice. We committed to a new set of rules and how to expedite it. But no sooner did we get that done than the following day, there were people in court saying those rules should be, and a petition in JSC saying the Chief Justice should be. So, we know our country, we know our problems, but all this notwithstanding, we must soldier on because I think we are on the right path.
All right. Thank you very much. Thank you very much, Prof.